Hello, everybody. It's Rick. It is September the 5th, 2018. If you need to reach me, you could do that by sending me an email at rick0327 at me.com. Okay? Please keep the emails brief. Okay? And I only do child support. That's it. I don't do traffic. I don't do anything else. Okay. Um, also, please, I'm from now on. I'm only going to be answering emails from people who have sent me a gift or are going to send me a gift. Okay. Please don't email me. Because you just want to ask me a question. Sorry, I don't do that anymore. All right. Dealing with this channel could be stressful enough, dealing with all the emails, and then I don't need to deal with some wise asses, who are too lazy to use the computer or not competent enough to use the computer. I had some jerk off last night, you know, asking me how to use a ticket, where to find who to send a ticket to, and I really wasn't in the mood. And of course, he was a wise guy. I just told him to Google or call the people on the ticket. So he's a wise guy, of course. Well, he's looking for me to help him. So I've discovered that by having this channel, it opens me up to dealing with people, and a lot of people. And I knew this when I was a cop, so I shouldn't be surprised. But a lot of people are screwed up, and really screwed up. And being that I don't like dealing with a-holes, I have to limit my exposure to a-holes. So unless you are going to send me a gift, have sent me a gift, please don't contact me. All right. Also, I've noticed that, I tend to be a nice guy. And again, I communicate with some people that have never sent me a gift. And, by me being courteous and responding to the emails, before long, I'm, in their life, and, them asking me questions, asking me to look at their paperwork. Again, I have my own channel to deal with. I have my own people to deal with. I don't have time to be going over your paperwork or, helping you feel better about yourself. All right. I'm not a therapist. Okay. So, I had to take a month off from this channel because my blood pressure was through the roof. So, again, unless you're going to send me a gift for my paperwork or you already have, all right, don't send me an email. All right. So, listen, you know, um, I told you guys I made a video about cease and desist, and also you could file an injunction. And what we're doing by the real reason why we're doing it is it's a collateral attack. Okay, so what we're doing is by filing a cease and desist, we're bringing attention to the court that you are demanding the respondent, could be your employer, could be the child support agency. We're demanding that they cease and desist, or you're filing an injunction because the order is void. Okay, the order could be defective on its face. It could not have, it will not have a judicial signature, and that's our way of saying that the order is void. And then that way, also, we'll be in a different court. You're not going to file a cease and desist in the same court than the child support court. Okay, you're going to be in a different court altogether. Now, listen, the court's going to know what you're trying to do, but they have to respond. Okay. Also, a writ of habeas corpus is another collateral attack, but the downside to that is, and we're, people that are filing it, we're finding that a lot of times these judges, they just ignore the petition that says non-statutory, and they also ignore adjudicated facts from the Supreme Court, and they make their decision solely on a statute. And they'll dismiss it, saying that, well, you don't meet the criteria because you're not a federal prisoner. Even though in we've made efforts in the writ of habeas corpus to say, well, we're not a prisoner, and the Supreme Court in Meyer versus Nebraska and Harris versus Nelson says you're allowed to file a writ of habeas corpus, for non-physical restraints and for deprivation of due process in a state court. So by doing just a cease and desist, you're going to point out that the order is void. It's defective. All right, and I'll show you how. So let's go, right? So, again, we're going to use a cease and desist or an injunction for collateral attack against a void support order or an IWO. Same thing, basically. Okay? Why are we going to use it against a collateral attack against support? I just basically told you, but I'm going to give you the definition. A void judgment is a nullity and is subject to collateral attack and may be stricken at any time. Very important. The passage of time cannot make it valid that which has always been void. All right? It says commit that quote to memory. Remember that, guys. A void judgment can never be valid. That also means that they cannot, a lot of these judges, because they feel that they're gods, they like to give you terms saying, all right, well, you got to go back to court or whatever. There are no terms. A void judgment is void. Okay? So it's a 1960 Supreme Court case, Ramagli or Ramali Realty versus Craver. Write it down, look it up. Okay? All right. Collateral attack definition: collateral attack on a prior judgment, a new case, not by direct appeal. Okay, so what that means is we're seeking relief. All right, we're just saying that we're ordering a cease and desist because it's again, the judgment is void, it's defective. Okay, and that's why we're doing it. Okay, so it's called an indirect attack. So we're asking the court to tell your employer, the child support agency, to stop taking your property because the judgment is void. Okay, and I just gave you an example: habeas corpus. Okay, collateral attack by habeas corpus. Here is the case law. Look it up. Okay. Okay, I said this before, collateral attack by writ of habeas. Sadly, filing a writ of habeas corpus as a collateral attack may face obstacles. And we are facing these obstacles, okay, because these courts know what we're doing, all right? But they also have, they as I pointed out before, they have ways of dismissing it by claiming statutory reasons, okay? So we're not going to go that way. We're just going to say that the order is void because, and we're going to give reasons why. Okay, there are no statutory reasons to say that an order is legally effective because it's not. If it's not signed by a judge, right? How many of you guys out there and girls have support orders issued by these fake judges? You cannot make order by a fake judge, effective if the Supreme Court says that it's a violation of the 14th Amendment, okay? Or it's not signed by a clerk, okay? And I'm going to point out to you guys, I used to talk about this a lot, and we're going to go back and check out a statute, okay? It's 28 U.S.C. 1691 that says all writs, which are orders from a court, has to be signed by a judge and signed by a clerk. Many of these orders are signed by fake judges and signed by assistant clerks. Okay? Although the Supreme Court has adjudicated that writ habeas corpus is a constitutional right against non-physical restraint of liberty, many judges refuse to acknowledge adjudicated facts and will dismiss based upon statutory requirements. Also, what we're going to be doing with the cease and desist or injunction, you're going to insist on a return date where you want to be in front of a judge. You want to argue this in front of a judge. We're going to try to avoid playing tag with a judge by doing it but through mail. What they want you to, they rather do this through the mail. You go to court, you bring the petition, you give it to the clerk, they accept it, right? They stamp it, all right? You serve the other party, and then what happens invariably is that you get a letter in the mail, and you've never gotten the time, the opportunity to be in front of a judge and argue these facts. Now, if you're not in front of a judge, they could just ignore these things in the petition. All right. So here we go. It may be easy to file a petition for cease, desist, or an injunction as a collateral. Cease and desist is a legally enforceable order from a court or government agency directing someone to stop engaging in a particular activity. By petitioning a court to cease and desist, to order a child support agency, employer, a bank to cease and desist, you are showing the court the many lawful reasons why a support order and income withholding order are legally defective, without legal force, and therefore void. Many of these reasons are constitutional. Okay? An income withholding order is a complete violation of the Fourth Amendment, because only a court of record, or just a court, can issue a warrant or some type of ordering the seizure of your property. Okay? And an income withholding order is issued by an agency, so it has no legal force. Okay? Now, the court will be on record for viewing evidence. Also, by doing this, you're introducing the void judgment, the income withholding order. It's evidence now. It's on the record. So you're going to introduce it as evidence, and you're going to present in the cease and desist why it's legally defective. Okay? Now, the judge is required by oath and bound by the Supremacy Clause, Article 6, Section 2, to acknowledge any constitutional defects. You have to remember that, guys. It's very, very important that you remember that a judge is bound constitutionally to uphold the oath of office and uphold the laws of the Constitution. Okay? The judge is required to acknowledge statutes and adjudicated facts that prove an order is void. I just told you about 28 U.S.C. Okay? Constitutional reasons why an order for support or IWO, income withholding order, is void. I just said it before, the Fourth Amendment search and seizure protections. Income withholding order is not issued by a court. I just said that. Here we go. 28 U.S.C. Section 1691, seal and test process. All writs and process issuing from a court of the United States shall be under the seal of the court and signed by the clerk thereof. Okay? Many of you have them signed by a deputy clerk. All right, this is a case law. Inasmuch as all writs and processes issuing from a court of the United States are required by statute to be under the seal of the court and signed by the clerk thereof. An injunction signed only by a deputy clerk of a district court is void, by the way. Somebody added that in there. The actual, I just fixed it, so it doesn't matter. It's void for want of judicial signature. Okay, how many times have we heard that, right? Quorum non judice. Okay, how many times have we heard it? Burnham versus Superior Court. It has been adjudicated by the Supreme Court that due process requires a trial by jury, right? We talked about that plenty of times. Okay, sometimes simple defects on support orders or IWOs are the best arguments for a judge to certify a void judgment. Okay, it's hard for a judge to deny it. Okay, IWO, not signed by a judge or a clerk. IWO, not signed by a court, is a violation of separation of powers doctrine. Okay, only a court within the judicial branch can issue a judicial order. Okay, any order issued by a executive agency is basically executive imprisonment. Okay, because you're being restrained. Okay, which is a form of imprisonment by an executive agency. Okay, and an executive agency has absolutely no judicial powers to order you restrained or order you imprisoned. It's impossible. It's a complete violation of the separation of powers doctrine and a violation, a deprivation of your rights. Okay? Support order not signed by a judge or a clerk is void under 28 U.S.C. So sometimes it's easier to use, we don't like all of their statutes, but again, if we have a statute that helps us, use it. Okay? They use it whenever they deem it, for their purposes, we can use it. Okay? Orders are void if signed and issued by persons not judges, right? Our commissioners, our support magistrates, our friend of the court, a DA, an assistant DA, an assistant attorney general. Any title not called judge, okay? All right, it's a quorum non judice, are void for a violation of the 14th Amendment. Okay? It's really that simple. Oh, here's another thing. I'm the only person, by the way, that I've seen on the internet that pointed this out. And in my, on that video with me before the judge, the Rita Quo Warranto video, this came in handy for me. I'm the only one I know that caught them doing this, that their orders are not entered as a money judgment with the county clerk's office. Okay? And many of you go and do it, you'll find that there are no records entered with the county clerk, and they are required. Okay? In New York State, under CPLR 5016 requires that orders by a judge are to be signed and entered by the county clerk. Also, in New York State, please, New York State, people only, Family Court Act 460 requires support orders to be signed by the clerk and entered in the county clerk. So it says the clerk in the county where the proceedings took place. The scam that they pull is they enter it in the clerk's office in the family court. That is not a county clerk. Okay? It doesn't count. All right? So this is just another reason you could say there's no record of a money judgment recorded with the county clerk's office. Okay? Court must order cease and desist because the order or the IWO is legally defective. Okay? By showing simple defects, the court is without discretion and must order a cease and desist. You do not have to mention anything about child support. Okay? And here's the thing. They're never going to be able to do that, these child support agencies. They only know one way of doing things, and that's by issuing their BS. Okay? So, we got them. All right? And again, there's a term, KISS. It's really, I say, keep it simple, sweethearts, because I don't want to call you stupid. It's really keep it simple, stupid. All right? So, but you guys aren't stupid. You're watching my channel. You're not stupid. All right? Good luck. All right? You're going to file the petition in a local court. You could easily call on the phone to see if the courts accept petitions for cease and desists. Okay? You don't have to tip them off why. You just say, I want to file a cease and desist. Okay? And you're not going to file it in the same court as these support orders. Okay? Because those aren't real courts. All right? Those are bullshit courts. So you want to file it like in a Supreme Court. New York State, it would be a Supreme Court. Okay, any law and equity court in your county. Okay, so you could just Google, where would I file a cease and desist in your county? Put your county and put a question mark. Okay, this is one of mine. Okay. 9 pages. All right. Notice of injunction. Notice of petition. Injunction. Look at that bad boy. That bad boy is nasty. I'll tell you, my orders are nasty. My affidavits, they are just so nasty. They cause these people to pull their hair out, I bet. Okay, so that's basically it. I mean, filing a cease and desist, in my mind, is a pretty simple collateral attack. Again, I'm for filing a writ of habeas corpus if you just want to get the whole thing squashed. All right, but if you want a temporary thing, a cease and desist might be the way to go. Okay. Also, if you get a court to certify by filing a cease and desist, by certifying that the order is void, you have it on record now, and you can bring it back to the court of issuance and say, oh, by the way, your order is void. Or you go to the child support agency and say, oh, by the way, this is void. This is no good. You got to stop. Okay. That's what happened with me. The judge, with my case, vacated it, and I had to travel into Manhattan. I have the video on my channel where I had to deal with this woman, a real nasty woman. Perfect for her job. Really enjoys her job. Really enjoys doing what she does. She really gets into, conning people. I've caught her in many lies. And I handed her I had to get an actual order from the judge to tell them to stop, because they wouldn't stop. Even though the original order said that the support order is vacated, they still wouldn't stop. They don't care. They're just, rogue criminals. They're criminals. You know what else I noticed? That whenever I release these videos, Monday through Friday, I usually always get a thumbs down right away, and I believe it's because these creeps are watching my video. Because when I release the videos on the weekends, I usually don't get any thumbs down. Not that I care, okay? I really don't. All right, but I'm pretty sure that these people are watching my videos. All right, but anyway, then I had to go to family court and get the judge to actually write an order ordering that, and then she's still like, I don't understand what you want me to do. Like, and I was like, and again, I told this story quite a few times, but I always get new subscribers, so I got to tell it again. And I'm like, it's not what I want; it's what the judge wants. But again, we're dealing with some really nasty people. But again, we're going to be filing a cease and desist or an injunction in a different court. Okay, we're not going to be dealing with the child support court. Okay. All right, guys. I'll talk to you guys later.